As I am seeking your lordship's indulgence to press a 389 for suspension of conviction.
Yes.
And let me give your lordship the 6 broad heads, those 6 broad heads. Well, as I respectfully seek a stay of suspension, a stay of conviction or a
Yes.
suspension of conviction. Firstly, because, Balas, on the very tests propounded in as many as 6-7 pages in the beginning of the sessions court judgment under appeal, under revision, the offense involved here is admittedly, and I use the word admittedly, on the basis of the 6 pages of judgments extracted by the learned sessions court, neither of a serious nature nor of moral turpitude, which are the 2 tests your lordship applies to deny, if at all, in an relevant case, the suspension of conviction. So that is going to be the first head, which I will show to your lordships. The second head, Balas, is to take the allegedly offending sentence or words and show that they do not relate to or invoke or inculpate any identifiable, suable class of persons. Well, if you make a statement like this, you cannot have anybody out of allegedly, not as per us, as per the complainant, 13 crore people. Anyone can be a complainant. That is not the law. There is no such identifiable, suable class to at all maintain a complaint. So jurisdictionally, the complaint would not be maintainable is going to be my second set of submissions.
But that will decide in the appeal.
No, these are all under 389.
389 only we have to see the suspension, why the court has not suspended this.
Correct. Now, one of the tests of your lordships for suspension,
Yes.
one of the tests of your lordship for suspension is that a prima facie case, a very strong case.
Appeal is pending before the consent trial.
Well, that will always
Yes,
be the
first
case in
appellate
389. Correct.
Yes.
So your
Now
lordships,
only 389 is, and against
Correct.
that order you are preparing the revision application.
my lord is right.
So we have to see just 389 only.
Only 2 things. In
We cannot
389,
go into the main proceedings, which is pending before the lower appellate court.
with one caveat, with great respect.
Hmm.
Under 389 now,
Yes.
under 389,
Hmm.
your lordships will grant suspension of conviction on the
Which
basis of prima facie case.
in
One,
which circumstance?
first is
Yes.
on a strong prima facie case.
Yes.
That's your lordship's first
And
test.
therefore, the learned first appellate court has considered your request and granted the bail.
That's on, but that's on sentence. I'm now talking of suspension of conviction only. Conviction. Under 389,
Yes.
apropos my lord's query
Yes.
that the main appeal is pending,
Hmm.
and what test should I apply
Hmm.
for a 389 suspension of conviction? My respectful response is number 1.
Yes.
The first test for stay of conviction under 389, which will always involve the main appeal pending. Well, unless the main appeal is pending, I'll never come in a 389 to your lordships.
Yes.
The first test is prima facie strong case. Why is that test given? The test is given because tomorrow, Mullahs, I win my appeal. In the meanwhile, very serious adverse consequences flow, which are irreversible. So a lordship sees that is there intrinsic strength in my case. And for that, Mullahs, the ground that the very complaint could not be filed on the basis of a non-identifiable, non-suable class will be directly relevant.
Exactly.
That's the second head, Mullahs. Because if a complaint could not be filed on the basis of a non-identifiable, non-suable class, in this law, your lordship doesn't allow anybody to walk in. This is one of those clear exceptions to criminal law, as your lordship knows, lordship is handling the criminal roster, that people can, in many, many offenses, anybody can complain, or largely anybody can complain. This is one of the rare exceptions in the IPC and CRPC, which say that only a person with locus can complain, and that locus cannot be eliminated by saying that anybody of a non-identifiable massive class group of people will constitute a complaint. That's my second head. My third head is that there are about 4 or 5 very serious ex facie. I mean, we are not asking for lordship to examine the merits. Ex facie on the face of it, vitiating factors of the trial on the face of it, which raise grave apprehensions about the process of trial, which led to my conviction, and which are bound to succeed in my appeal, and therefore today make out a very strong prima facie case. So in prima facie case, both these last 2 points will apply.
Yes.
Serious vitiating factors of the trial. My fourth is, to separate one of those vitiating factors, namely 202, and deal with it separately, because 202, which your lordship inaugurated as a special amendment, as a special dispensation, was intended to protect from frivolous, hasty prosecutions, precisely such situations. And here, Bills, no satisfactory answer is given to your lordships, either by the learned magistrate or by the learned sessions court, as to how 202 has virtually not been dealt with except one point, that it was raised late. Your lordship has held repeatedly, A, it is mandatory. B, if it is mandatory, it has to be a jurisdictional point. Suppose I didn't raise it at all. Even then, the judge has to apply his mind and do the inquiry. For example, limitation, to take a civil law analogy. Civil law analogy, he may not raise limitation. But if your lordship is bound to it, your lordship will see, and your lordship can suo motu and should suo motu take it up and dismiss or allow. That's the fourth aspect. The fifth aspect is that, and this is quite astonishing, the offending sentence or offending speech, absolutely no documentary evidence or no evidence, forget the word documentary, no evidence in terms of the law, in terms of the Evidence Act, in terms of the IT Act, has been produced to justify at this stage proceeding even to a conviction. To just digress for 30 seconds,
yes,
your lordships in a speech will have broadly three possibilities. Either I am the complainant, I have myself heard him saying this, so I am the witness, I depose. The second is I was not there, but my learned friend there is a reporter or a journalist who has seen it, heard it, and reported it. He can depose. A third is neither me nor reporter, but a direct person who can authenticate it. Here, your lordship will find that none of the three apply. Therefore, under the IT Act and under the Evidence Act, there is absolutely no proof of the offending sentence ever being uttered. Without that proof, a conviction can't lie, per se. Then, a very, very important last point would be the irreparable, irreversible nature of the consequences. Why is, at the end of the day, 389 made? 389 is made because your lordships have certain, and in this case more than any, extraordinary consequences of conviction. Now, anyway, conviction has bad consequences. I mean, one can't travel, one can't do this, that. But in the case of a public servant or a legislator, be it parliament, or it has very serious additional consequences because, such a person, suppose he misses representing his constituency
then
for some time.
More, in fact, duty towards the public at large. He is representing the people at large.
Yes.
He has to make his statement within limits and within bounds.
No, therefore, there is no additional liability for a public servant. Suppose, a public servant makes a statement. Let me put it like this, apropos my Lord's query. Suppose, otherwise, he is a not public servant, I am a public servant. Otherwise, your lordship find that this is not defamation. Your lordship will not make it defamation because I am a public servant. That's not the law. The law is not that on the face of it, the offense is not defamation, but because a public servant has done it, therefore it becomes defamation. But that is not the point I'm making, The point I'm making is that when your lordship gives or does not give 389 suspension of conviction, my lord looks at irreversible special consequences. There is not that consequence for an ordinary person. Today, it has a consequence on myself. I stop representing. Suppose, I have missed, actually in this case, I have missed 15 days of the last session. I may miss the next session completely. So that's a consequence to yourself. The second consequence is to the constituency you represent. That constituency, the collectivity of that constituency is deprived of your representation. Third, it leads to the drastic consequence of a re-election, which makes, suppose, I win my appeal after re-election is announced. How does anybody, including a court, reverse it? Can't be reversed. It's irreversible. Your lordships, have done exercise of 389, where the admitted test is, it has to be a concurrent stay of conviction and a concurrent stay of sentence. Now, your lordships have, and I'll start with that point, done that exercise for very serious cases.
Yes.
Mine is a case which is neither serious nor moral turpitude. Therefore, if for sure I am entitled to that, so let me start with that first point.
Yes.
Therefore, my first point is, please note these cases,
Yes.
and your lordship will see the consequences. In para 5 of the Sessions Court order, which is impugned, a case cited is Shyam Narayan Pandey. Your lordship will see para 5. It is cited, lordship need not read it, just note it at 63, it is there.
Yes.
Which is a Sessions Now, my lords, the point I'm making as my first point, this is my first point, 1A, your lordship may call it, that the learned sessions court relies on these cases to deny me stay of conviction.
Yes.
To deny me. My submission is that the very same cases he relies on operate in my favor, because the test in the first 6 pages of this order your lordship is holding is that cases of seriousness and moral turpitude I should deny or should be denied. But by contrast, defamation with a maximum sentence imposed does not fall into that category.
Yes.
So what was the first case which is mentioned in para 5 minutes?
Yes.
That case is a case of life sentence, admittedly. Please note that it's a case of life sentence.
Yes.
Therefore, my lords, that case is a wrongful, inapposite, incorrect citation by the learned sessions court to deny me bail. You are, my lords, actually by contrast making out my case. By contrast, I am not a life sentence case. I am, my lords, a non-cognizable, bailable offense case. Then why do you cite this judgment? Error number 1. Error number 2, my lords, the other judgment is at page 61, para C, Navjot Sidhu.
Yes.
Navjot Sidhu was what, my lords? It was a case of 302 murder, then my lords, ultimately found in 307.
Exactly.
Again, you are citing it to make the point that your case, that is the today's case, is serious enough where here this should be denied and your case therefore should be denied. So the first point is that again, my lords, is an inapposite, incorrect. By contrast, I have stay of conviction. He got stay of conviction. The third case, my lords, cited the third case is Ravi Kant.
Yes.
Ravi Kant is cited at para D, T for Delhi at
D
page
for
61.
Delhi. Yes.
Well, this is extraordinary. It was a 376 rape case and a 366 abduction case. So the test of seriousness applies in the reverse in my favor. You are citing rape, murder, abduction cases. So you are, Malus, applying elephants to mice, not apples to oranges. You are applying elephants to mice. The fourth case, Malus, cited at page 62, para E for England,
Yes.
is Dattatreya.
What is the conviction imposed by the trial court in Dattatraya's case?
Prevention of Corruption Act.
But what is the conviction period? It is for
No, your lordship has said there are two candidates. That's why I'm
Yes.
your lordships have said that either it's a serious case, which is life and 10 years,
but then the
or if it is
Honorable
less.
Court has said that it is in rarest of the rare case only to be considered. The 389.
Let's kindly see.
Yes.
Where the offense, the punishment is less, then you can still be denied for a different test, moral turpitude. There are
That
two
was
tests.
considered in this
That is
Dattatraya
considered in Kumbat. Kumbat was a PC case.
Yes.
So PC falls under moral turpitude. PC case falls under, so I'm saying, well, one is a case of murder or serious long offense, a long punishment. The other is a case of moral turpitude. I'm neither. So by contrast,
But then in that judgment, paragraph 26, 27, and then paragraph 111,
yes,
the Honorable Trial Court has considered Honorable Apex Court guidelines.
so therefore, I'm showing lots of guidelines, but kindly see, the guidelines are only these two.
Yes.
Serious offense, long sentence is one guideline. The other is moral turpitude. That is why your lordship should really be seeing each of these cases by name of the nature of the offense. There's no other guideline. The principal guideline, lordship will just note, the guideline in Shyam Narayan Pandey, the main case,
Yes.
in Malus para 6
6.
is serious or moral turpitude. I am adopting the guideline which is followed from my lord just now. Under that guideline, I am dealing with one by one all cases. Each case is either a serious case or a moral turpitude case.
Yes.
Where is the case where your lordship has denied 389 for neither a serious case nor a moral turpitude case? There's no case like that. Now, on the contrary, 302 you have allowed conviction stay with the 302 case in Navjot Sidhu. You allowed it. So, on all these three tests, I am entitled to the is again a PC Act case. That is not cited in the Sessions Court. I'm just giving it.
Yes.
It's again a PC Act case.
Yes.
Narang, cited in para A, page 59,
Yes.
is again a PC Act case, 5.5 years given. Rarest of rare is that you can grant even in a serious case, even in a moral turpitude case. A fortiori, Malas, your lordship is not going to apply Malas, the rarest of rare case to a case admittedly non-serious and admittedly non-moral turpitude. That would be turning the law on its head, Malas. So, Malas, that's the first point. And then Malas, very important case cited is K.C. Sareen. K.C. Sareen again is PC Act, page 60, para B.
Yes.
Page 60, para B. So, Malas, I have given your lordship 7 examples. The Learned Sessions Court starts his judgment over 6 pages by citing, and your lordship, just give me a minute on page 63 minutes. Can you turn to 63?
I'm on 60.
That rarest of rare, which my lords formulated just now from Malas Pandey, is for directly at page 63, para 6. It is there. Is for serious cases also. There is no bar to a 389. It is not that your lordship says that a serious case of murder I'll never give. Even there you will give and can give, but you will give it more sparingly, quite rightly. Therefore, Malas, I am clearly a fortiori case. It is undoubted that I am a fortiori because nobody can suggest that I fall in the moral turpitude class or a serious class. In fact, Malas, a non-cognizable, bailable offense, which is not, Malas, against society at large, is a third important point. The idea, Malas, of your lordship's approach in this is that there are offenses against society at large. Otherwise, Malas, why does your lordship have this provision that a person directly defamed can alone maintain a complaint? Your lordship has that. Malas, for a murder, it is not that only the victim's family can file. This is the difference your lordship makes, because your lordship says that in such matters, Malas, it can't be called serious or moral turpitude if it is not a societal or anti-societal offense. Therefore, Malas, I find no reason in the first 7 pages. It's an error of law. Yes. Malas, it appears to be a Malas clear error by the learned court below by applying 6 pages of judgments which apply in the reverse in my favor. Now, just see, Malas, the quotation at 63. And Malas, these are not quotations, they are underlined by the judge, as the lordship has noticed. So, that obviously, the basis of his judgment is these underlinings. Now, just see one of them. It has been consistently held by this court, unless there are exceptional circumstances, the court shall not stay the conviction, though the sentence may be suspended. There is no harm. Now, this means that you shall not stay in serious cases, because the next para makes it clear. Otherwise, Malas, what your lordship would be told is that you will not stay conviction in let's forget this case for a minute, Malas. Let's take a case of a, I can't give an example. Take a 1-year offense case, anything. The most trivial offense, bailable. Malas, if the test of 389 is that in a 1-year bailable, non-cognizable, non-societal offense, your lordships will rarest of rare case suspend 389. That will be turning this on its head, Malas. Now see, Malas, this. Law Commission is referred to in para 6. See the next line. It was regarding the release on bail of a convict where sentences of death or life or not less than 10 years. If the appellate court is inclined to consider release of a convict of such offences, the public prosecutor has to be given an opportunity for showing cause and writing against such release. This is also an indication. I am reading this for lordship. This is also an indication as to the seriousness of such offences and circumspection which the court should have while passing the order of stay of conviction. Just pause here. What is, Malas? This is also an indication as to the seriousness of such offences. Certainly, if Malas, if I come with a serious offence to your lordships of 302, I can still ask that these circumstances, but your lordship will say, I'll consider it's a serious offence, I'll do it sparingly. Your lordship will not apply that rarest test where the offence is not serious. That is the only meaning of this sentence, which can be. Similar is the case where this is category 2. There may be, Malas, seriousness is defined one way by the length of sentence. Now, there may be moral turpitude cases with less period of sentence. So, the court takes care to put that category. Admittedly, I am using the word admittedly, non-cognizable and bailable offences fall under neither category, clearly. Similar is the case with offences involving moral turpitude, and prevention of corruption is the best example. If the convict is involved in crimes which are so outrageous and yet beyond the suspension of sentence, if the conviction also is stayed, it will have serious impact on the public perception on the integrity of the institution. Such orders definitely will shake the public confidence in judiciary. That is why it has been cautioned time and again that the court should be very wary in staying the conviction, especially in the types of cases referred to above. And it shall be done only in very rare and exceptional circumstances of irreparable injury. This whole para, where the last line, the suffix is underlined, relates to the previous part, serious and moral turpitude. So that's, Malas, that I was. Therefore, Malas, this is the first important point. This applies, by the way, right from the beginning of the judgment till where he finishes citing the cases, which is all these pages you should have seen virtually from the first page on to about the 7th or 8th page. He has given about 6-7 cases. Learned judges underline them, but with great respect, this is a patent error. The cases which you have relied upon and underlined are themselves the cases with the greatest of respect and humility you have misunderstood and misapplied. Now, here, if I may digress for 2 minutes and ask your lordships to come to a chart, which will give your lordship an idea of how much more serious offences. Now, this is before I read it, I must preface by cases relating to MPs, MLAs, where offences far more serious have led to a stay of conviction. Now, I'm giving you that chart in a minute. Kindly turn to that chart, at page 685. Same volume.
Yes.
Now, if your lordship will see, lordship may do me the favor first of marking on the side in each of these. Then I'll elaborate it. It will make it easier for your lordship. So, lordship does.
Yes.
The first is a PC case. Just your lordship will write PC on the side. So, lordship makes it easier for your lordship. The second one is a PC case. Mohammed. The third one is also called Mohammed Lakshadweep. This is interesting. The High Court has granted stay and I am appearing in the Supreme Court for the person who has a stay. The state is in appeal. This third one, which is also another Mohammed, Sayyid Mohammed from Lakshadweep, it is currently going on in the Supreme Court, is a 307. Actually, the allegation is 302, but the conviction is 307.
It is under IPC.
And mind you, every case I am giving here is a stay of conviction. Stay of conviction. In this, the third case your lordship is holding just now, the High Court gave a stay of conviction. Matter went to Supreme Court by the complainant and by the state. It is pending. I am arguing it for the respondent. The learned court number 3, Justice Joseph, has not given a stay of the stay granted by the High Court. It's going on right now, is being listed every. Now, all these are MP MLAs. All these are conviction cases. All these are stay of conviction sought. All these are disqualification consequences. All of them.
Yes.
So, it's very clear that to suggest, and that is the error I say with great respect of both, in particular the Sessions Court, that as if 389,
yes,
also kindly consider, apropos what my lord said, I'm very grateful for that. Your lordship is not here to reduce 389 to vanishing point. 389 exists in our books. No interpretation can be advanced by the complainant to reduce 389 to a vanishing point. Yes, formally I keep it on a pedestal, but in actual thing it's a hollow shell. There is no role for 389 to play. When will 389 play a role? If these cases far more serious have led to a stay. Otherwise, the only interpretation would be that in no case, even where it is non-societal, non-anti-society, even if it's non-moral turpitude, even if it's non-serious, in no case can you give. Because rarest of rare means virtually you can't give. What other circumstances, kindly examine in your lordship's mind, what circumstance can possibly exist which can then tilt it from the non-giving to a giving case? That's the question your lordship applies as a test. Now, then number 4 is a 332 case. That is hurt to a public servant. Actually, it's a more serious case. On duty, I go and slap somebody. On duty, I go and assault somebody. So it's a fairly serious category. 3 years and etc. That's number 4, Khatik's case. Number 5 is a 7-year maximum case. 420. That is Kushwaha. 420. All conviction, all public servant, all stays granted. 6 is a very interesting irony to it. 6 is Prahlad Lodi. Prahlad Lodi is a case of hurried disqualification. I'll read that in a minute. And in this case of Prahlad Lodi, the conviction is on 31/10/2019. 31 October 2019. And sentence is on 4/11/19. Disqualification order is on 2/11/19. 2/11, that is 2 or 3 days later. And appeal is on 4/11. In my case, my conviction is on 23 March 23. And the disqualification order is 24th of March. There is no way anybody can file with supersonic speed unless we just throw papers at your lordship without filing a proper appeal in one day. Now, there again, Prahlad Lodi is a stay and of conviction. And last is Olekar's case, Karnataka, again a stay. Now I'm asking myself the question, how is it possible that your lordships has so many examples of serious, not a defamation case, which is the lowest rung of this, lowest, not a case which can be said is not serious. This would be a discriminatory application of the law at the behest of the complainant, which your lordship doesn't counter this. Let's look at the balance of convenience just for a minute. Because now I will come back to those 4 points of merits later. But I'm just, since I'm on this part, I'll just finish this part. Well, let us take all of them together and list them. Your lordship has to see, of course, prima facie case. There are my first 4 points. I have to come to them. I've already made 1 point, but I will be making more points. Now, assume there is a prima facie case. Then what extra I'm asking myself? And I'm attempting to answer it respectfully before your lordships. One is, the irreversibility of consequences. I'm not saying any one will matter, I'm taking the totality, but I'm just itemizing. Now, today, forget this case, anybody. I am, a public servant in a legislature. I am disqualified. 1 session of parliament goes, a 2nd session of parliament. So we just stop there, only 2 sessions. Let us say I have missed 60 days. Now that 60 days entails at least 2 or 3 losses. It entails a loss to me of raising my democratic voice in parliament. It entails a loss to my constituency of having their voice raised through their elected representative, chosen representative. And it is a general detriment to the public interest of the country that parliament is without one voice, or legislature is. My question, the first question to myself is, on the 6th month or the 12th month, I reverse my conviction, I am acquitted. Is it ever possible by any contrivance of the law or of the learned judge to restore to me those 3 losses? Obvious answer is no. I mean, even if lordship tries, your lordships can't do it. It's irreversible in the extreme. Now for a minute, assume that my learned friend is not an MP MLA. He has adverse consequences. He also gets a 389 suspension. But in the case of an MP MLA, it is purely on the face of, by the nature of the whole issue, it is irreversible. It is possible that for him, it may be slightly reversible. Look at the nature of this. Then take the other example. Suppose this continues for 3 months or 4 months. There is an established election commission circular that you will not keep a constituency unrepresented for too long. I mean, not that I will have an election tomorrow, but normally within 6 months, you need to have somebody. You can't just keep it vacant. So what they normally do is, if a by-election is happening on the 4th, 5th month, then they'll club it with that. But if a by-election is happening after 9 months, they may have a separate election for this because they don't want to keep it. Now, it's a rule of thumb. I mean, it can be 5 months, it can be 6 months, but normally they don't do that. Now, let's suppose your lordship finds that this person is disqualified on the 5th month. Election commission naturally goes ahead. The constituency is vacant on the 5.5 months it has election. And later on, I win my appeal. And meanwhile, Mr. Rahul is elected in that by-election. There is no power on earth. Even a lordship's mandamus can't say, Rahul, you vacate your seat and Singhvi will come back again. No power. Nobody can say that. He's elected. And I have not stood against him. So I have not lost. No election petition can unseat him. No election petition can install me. Well, these are balance of conveniences. For what? For a murder I've done? Have I put my hand in the till and have been corrupt? Have I murdered somebody? Have I assaulted somebody? I've done defamation allegedly on a first appeal. Defamation has at least 3 more appeals. I have done a criminal defamation at the most at a first appeal level I am standing. I would be disqualified from entire 6 or 8 years, or in effect rendered irreversible by a by-election. And I can't stand, I can't fight the election, and the argument of the complainant is that lordship should read 389 to mean that rarest of the rare case means like a death penalty. Rarest of rare doesn't mean death penalty. It means in a very serious case or a moral turpitude case, your lordship will use the power sparingly. Otherwise, your lordship is being asked to reduce 389 to vanishing point in a category of cases where there is more consequential adversity to a public servant than in a normal case. Well, the normal person has a problem of his wife, unwell, family, livelihood. The additional problem with a public servant is that he loses the seat forever. In that case, you are saying that there will be no remedy in a 389 for a non-serious, non-moral turpitude case. Well, how can that be the law? So on that, well, suppose your lordship were to ignore everything else. Suppose your lordship were to ignore, not that your lordship should ignore, I am coming to the prima facie case. I am just saying, suppose your lordship were to ignore the merits on a pure balance of convenience. Well, balance of convenience is not only civil law, it is also criminal law in 389 in such situations. All the issues, balance of convenience. What is 389? It is ultimately, in simple terms, your lordship sits on the other side also, civil side, 151, balance of, it is basically that, look, ultimately your conviction will be reversed. How can we punish you irreparably? Then we give you a window for a court to consider. Now, with great respect, this alone on irreparable injury, irreversible consequences, with the additional special unique consequence of disqualification, which doesn't apply to a normal human being. It applies only to a legislator. If this is not enough to suspend conviction, then what additional circumstance can anybody have ever? Then, actually, by denying in such a case, as the complainant wants your lordship is actually rewriting 389 with a proviso. My learned friend, and I'll come in a minute to his locus in a minute, to be at all here, but that's separate. Your lordship is really being asked by a person with zero locus to say that, look, 389 says you may give a suspension of sentence, provided, however, in the case of a person with special adversity of disqualification, it can never be given. Because if it can't be given disqualification, when can it be given? I can't think of any case where lordships can give it. Now, let us come to those 4 or 5 points of clear absence of a prima facie case. I'm sorry, this chart, I have not finished reading some part. I'm sorry. Now, lordship will take it. We have given a compilation,
yes,
which has all these cases.
Yes.
Now, either I waste your lordship's time by reading all the cases, it will take time unnecessarily. So, with your kind permission, I will just summarize each case in the chart itself.
Yes.
Remember, on the top, the real point takeaway is, it's a case A, all cases are A of public servant legislators, all of convictions, all of stays. Of conviction, not sentence, we are not considering sentence. All of them. Now take the first one, this Indra Kapoor, which is a PC case. Just keep following it there. As your lordship knows, that suppose the punishment on me is obvious, that is, of course, from my limited experience of criminal law, I have very rarely found conviction than criminal defamation. But where conviction is there, I have never seen a sentence of more than 3 to 6 months. It can happen theoretically. But it should be remembered that in 1 year, 29 days and 11 hours would incur 1 year, 11 months, 29 days and 11 hours would incur no disqualification. It is only 2 years which will incur it. Now, keeping that in mind, come to
section 8.3 of the people.
8.3. So, maximum punishment for a alleged first-time offender in a non-cognizable case, in a bailable case, should effectively make him lose his seat permanently, irreversibly. Skewing of the democratic operating space, because you would have multiple people, and remember, the offense has to be kept in mind. Your lordship is not talking of a murder charge, your lordship is not talking of a prevention of corruption. Therefore, it's a very serious, extreme situation which cries out for redressal. 389 was only created for this. There's no other place it can operate. Now, I'll just see these cases. Kapoor is the PC case I mentioned, and this saves time a lot because this is only the relevant para which are given there. No, I'm reading the same thing in the chart.
Chart, I have seen that. I have marked it.
I'm grateful. See the whole thing. I don't need to read the whole judgment. Lordship will see the whole judgment. It's all there. Well, though appeal is to be decided by this court on merit, but having taken note of the aforesaid aspects, this court is of the view that case at hand comes under the category of exceptional case. What comes at hand? PC case comes under exceptional case. In case conviction is not stayed, petitioner's political career would be ruined. I would request my lords to mark whatever lordship thinks is appropriate, but these are vital words as far as I am concerned. Well, incidentally, if time goes and there is no stay of conviction, the disqualification is 8 years. Because 2 years is anyway, and then 6 years. For the reasons stated, this is well as heart of democracy also, even though you are a convict, your chance of well as again, this court finds that on account of conviction, petitioner has been rendered disqualified to be a MLA, and in case conviction is not stayed, she would not be able to contest the elections, which are otherwise bound to be held on 12th of November. Here, well as the maximum, about 2 months have gone, and the election commission would not normally wait for more than a couple of months more. Normally, it's 2 to 3 months more. Since conclusion of appeal may take some time, and in the event of appeal being allowed and the applicant being acquitted, she cannot be compensated for the loss which she may suffer on account of her losing